what's up? It's your girl Neek, and you're tuned in to Neek at Night. So earlier today, I went live while they were reading the plea deal. It was a lot of anticipation, a lot of excitement. I was like, oh my God, what does this mean? I gave my predictions on what I thought that was going to be in the plea deal and so much more. Now in this live, we're going to be doing a closer look and really listening to what he pled to, because I'm going to be honest, when I was live, my heart was just like boom, 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 boom. Like, what does this mean? What does this mean? Like, no way they're giving him a sweet deal. This got to implicate other people, you know, all of those things. So now that my nerves is calm, I am calm, cool, and collective, we're going to give a second look at his plea deal. We also have the document that states what he pled to, and we also have confirmation that two of the defense attorneys have shut down a plea deal. Doug Weinstein came to the internet and claimed or made a statement and said that he declined the plea deal for Gotti. In so many words, he said that he presented the deal that they offered to his client. His client rejected the deal. So therefore, he is going to continue to zealously advocate for his client. Now, in addition to Doug Weinstein rejecting the plea deal, according to the news, the other person who rejected their plea deal was Max Sharp. Now, if you guys know Max Sharp, he represents Shannon Stillwell. And in my opinion, he was the one that has the most exposure in this case. I'm going to play a little clip of the news where the lady talks about how Shannon Stillwell denied his plea. And then we're going to have a closer look at this one.
Two attorneys for two of the defendants said that their clients would not accept plea deals and would continue fighting for their innocence. They include Shannon Stillwell as well as Diamante Kendrick, a.k.a. Yak Gotti, both of whom are charged with murder. Now, also very important to note that Judge Paige Reese Whitaker has not declared a mistrial, saying that she had considered doing so. And legal observers say that the plea deal indicates a mistrial is not imminent at this time. Tracy?
Breaking now at 3 in Georgia.
All right, now let's go to what Doug said, and then we'll take a closer look at this plea. Now, a lot of people are stating that the plea does not implicate any of the other defendants. I'm going to talk about that a little bit more as well. So let's go.
So you saw Mr. Nichols plead out today in the YSL case. Obviously, Mr. Kendrick did not plead out. We are going to continue to fight for his life. We are going to continue to make the state prove their case beyond a reasonable doubt. The last few days have been a trying time, I guess, for a lot of people involved. A lot of things have been in motion, but we are where we are. And let me say something to folks talking about plea deals. The issue of whether to take a plea is an issue that is solely up to a defendant in a case. It is not up to their lawyers. It is not up to their family, their friends, their supporters. It's not up to the prosecutor. It's not up to the judge. This is a critical decision the defendant has to make. And lawyers are also obligated whenever a plea offer is made to pass that offer on to our clients.
All right, so right here, he's basically saying, listen, when we get a plea, whether we feel like it's in his best interest, not in his best interest, we have to give it to our client. He decides what he decides, and then that's that.
But that's that. And now we continue on. And we continue to fight what I think is the good fight. So I guess, as I'm wont to say in the evenings before trial, stay tuned and we will see what tomorrow will bring.
All right. So as you can see, Shannon Stillwell, which is Max Sharp, they have rejected the plea deal. Doug Weinstein and Yak Gotti have also rejected the plea deal. Now that leaves Young Thug, the other Quay, Little Rod, who could accept the plea deal. Now let's have a closer look at this plea deal and if this will be a bad thing for Thug. Now, I'm going to say, because like I said, it was a lot of emotions. We have been having a lot of buildup, waiting up into this moment. What is it going to mean? And at this point, we have not seen a plea deal that did not require any of them to testify. So in my predictions, I predicted that, number one, he's going to have to testify against the other defendants. My prediction was also that it would mean that he would have to flip on the other defendants.
All right. It is my understanding that we have a plea to be tendered for Mr. Nichols. Is that right? That's correct. All right.
Your Honor, may we approach?
You may.
All right. So we've seen the defendants in this shot, and then when they came back into the camera, all of the defendants were gone, and you just seen the lawyers.
And Mr. Harvey, Ms. Westmoreland, and Mr. Garland, who's going to be taking the lead going through the plea? Okay. All right, Mr. Harvey, do either you or you, Ms. Hilton, need this plea of guilty and waiver of rights form back?
All right, so when I was watching the trial, because I'm giving you guys a live a recap of when I watched it live versus I'm just relaying it to you. So when I looked at this shot and I'm like, okay, Silver Fox looks disappointed. Doug looks disappointed. We don't see their defendants next to them. You see Nichols looking sad and disappointed. And then it's going to pan to the other defense attorneys and they look disappointed. What was going through my head and what I expressed on my live was I thought that this meant that he was snitching. I'm like, oh no, there's no way he didn't snitch. This looked like he's snitching. Oh, heck no. He must have snitched. Okay, so let's continue.
Thank you.
Okay, y'all saying you hear me good? Shout out to Paralegal Institute. I think that Paralegal Institute is what's covering this case as well. Is that I can't click on it, y'all. Is Paralegal Institute the one that's been killing it in coverage on this case? Oh, can you please come up, please? If you can, you have been doing so phenomenal on this. I would really love to hear from you. I really would love to hear from you. That would mean so much. Let me know. I dropped the link for you. I really want to hear what you have to say and like have dialogue with you about it and what you were thinking and all of those things like that. But okay, so let me get back into it. Okay, so like I was saying, sorry, let me know if he wants the link, y'all, and so I'll give it to him because I really want to talk to him if so. But anyways, all right, so when I'm live, I'm giving my honest thoughts. I'm one of those type of people that I'm going to give my honest thoughts, like what's actually going through my head, what I'm actually thinking at the moment, and all of those things. So in this particular moment, I'm thinking, oh no, this is bad. They removed the defendants. They all have to leave out. He's the only defendant there. He's signing a plea deal. And as he's signing a plea deal, in my knowledge, there was no prior plea deal that required anybody not to testify. Gunna, even though he did an Alford plea, they said that he is subject to be called to testify. Slime Life Shorty also, in his, you seen he had to testify. And in all of the plea deals, whether they called the person or not, it stated that they would be subject to be called to testify. So when I'm watching this on live, I'm thinking there's no way that all of these attorneys are looking sad. There's no way that he got a sweet deal that would require him not to snitch. And boy, was I wrong. Okay? he did not have to be called to snitch, and that's still up in the air, and that's still up for debate, okay? That's still up for debate. So I'm going to drop the link. Thank you so much. Don't go nowhere, paralegal. I'm going to play just a little bit more, and I'm going to give you the link. Just 1 second.
All right, Mr. Nichols and Mr. Harvey, whenever y'all are ready, you can come on up to the podium.
Mr. Harvey said he's signing the indictment.
Okay. Whenever y'all are ready.
Your Honor, I'd like my client to be present for this. He's a member of the public, and I would like him to observe this, and he has a right to be here.
Okay.
Thank you.
Can we get
Are you granting
Mr.
that?
Kendrick
Thank you.
out, please?
Hold on, Judge. Hold up.
Stand by.
Oh,
This for right now. So up until that point right there, when you were watching this, what were you thinking?
All right, so I had to step out for a second, but is this the part where Weinstein asked to approach?
Yes.
I can't say I was thinking because I'm talking constantly. Like, I don't have time to think. When I'm on live, I have people there, and I'm literally just trying to keep people, attention. But I figured it was what he had just said, something along the lines of he wanted Mr. Kendrick present. I did think it might be some kind of, the factual acknowledgments, how with Monk Tung he had to acknowledge all of these things. So I thought he was like, let me get my client in here so he can see what you about to say about him, that kind of thing.
Right. That's
what I mean?
more along the lines of what I'm asking. Like, what did you think this meant for the other defendants in that moment? That's what I was meaning.
Yeah. So I don't know if I don't want to jump ahead. You might have a flow that you have in mind, but there was a thought that I had coming into this whole thing, and I want to share it if I can.
Go ahead. Yeah.
Okay, so this is the thing. This is the perspective that I have and that I had. Remember how we got here, right? We got here because Slime Life Shawty's on the stand, right?
Mm-hmm.
And he says free Quay, right? Remember that. And sorry about my background. Let me see if I can take this off. He says free Quay, and when he says free Quay, let me just blur it. That might be better. When he says free Quay, there were two Quays in court at that moment. You had Quay Nichols and Quay Harvey. Mm-hmm. So before we get into court today, this was my theory. My theory was once we started hearing about plea deals, I'm working it through my mind. And I was like, okay, what's the most likely thing that's going to happen? This is today. What they're going to probably try to do is get Quay Nichols and Quay Harvey off this case. That would moot the whole idea of a mistrial without prejudice. Because remember, that mistrial without prejudice, at least from my thought process, was with respect to Quay. We just didn't know which Quay it was. So if we can get the Quays off.
It was first called out by Westmoreland. The Quay Nichols.
Correct.
It was
right. That was she called it out first. Then Matthews joined because his guy's name's Quay too.
Right.
So we're like, we don't know which Quay it is. That's what everybody thought. So my thought was, as of today, not initially, but as of today, is like, okay, maybe what the prosecution is going to try to do is get the Quays off, both of the Quays off, so that they can totally get the mistrial without prejudice issue mooted and off of the table, because the ones prejudiced by the free Quay are the Quays. So if you get them off the trial, you get them a plea deal. Now you can continue with the other four defendants. You still have Young Thug. Of course, this is from the perspective of the prosecution. You still have Young Thug. You still have the capo, the big boss. You get the Quays out. You get them a plea deal, which is a conviction at the end of the day. And you get to moot that whole question of who is Quay, free Quay, all that's gone. So that's what I was thinking. So as we go in and I see Quay, he looks like he's about to sign something. I'm like, okay, well, there's one of the Quays, but where's the other Quay? So that was part of my thought process at that time too. I'm trying to find the other Quay in the courtroom because I'm thinking they need to take care of both of the Quays. So, so that was also one of my thoughts at that point.
Okay. So I'm gonna play a little more. Do you got a little time to hang out with us for a little second?
Yeah, I can hang for a while. It's not a problem.
Okay, so I'm gonna play a little bit more of the plea deal, and I'm gonna keep your audio up. So if I'll just mute. If there's a point that you want to chime in, because I'm gonna put the plea on the screen. If there's a point that you want to make a point at and tell me to pause, just let me know, okay?
All right, will do.
All right, so let me bring it back up. When I was watching it again, when I'm looking and I'm seeing the look on his face, the look on his face, the attorneys, and then the way that Shannon Stillwell looks at Quay when he walks by him.
I think that's on. Thank you.
You see the glare from Young Thug?
Now let's have him at the podium because he's going to have to take an active part in this entry. All right.
Okay, sure.
Sergeant, can you swear him in, please?
Raise your right hand. So I affirm testimony you give the truth, the whole truth, and nothing but the truth.
Yes.
All right. State, spell your first and last name for the court. So allow me to the mic, please, sir.
Quamarvius Nichols. Quamarvious. Last name Nichols. Nichols.
Did you get that, Judge? Yes. Okay. Do you want to do it again? All right. Slow down. Your name. Spell it for this young lady right here.
Okay. My name is Quamarvius Nichols. First name Quamarvious. My last name Nichols. Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvius Nichols on indictment 22 SC 183572?
Yes.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
Yes.
All right, I'm gonna play it, but I'm gonna just pause it one more time. So in this moment too, in my head, I didn't verbalize it on my stream, but I'm thinking Miss Love is most definitely demoted. Now I don't know for sure. I can't say it's factual, but in my head, in my opinion, that's what I'm thinking. Like, she not taking this plea deal on. Like, she's not the one that's vocalizing it. I'm like, okay, she on pushing paperwork duty. That's my opinion. That's not a fact, but that's what it looked like.
How old are you?
29.
And how far did you go in school?
I got my GED.
Did I hear you?
I got my GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carried a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that that is what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this man with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand that as a part of the negotiated agreement, the state will null, prosecute, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon? Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Now, when I was watching this, I didn't catch this, but it took me afterwards. I realized that him entering in this plea right at this moment, and the judge had to accept it. So she could have been like, all right, I reject it and I sentence you to this. That sounds like that's what Hilton basically just stated.
Are we not going to talk about the fact that they just the murder charge?
Let's talk about it.
Can we say the word? We can say the M word on here, right?
Go ahead.
Or no? Or do we have to say unaliving?
Go ahead.
No, listen, I just want to do the right thing. I mean, I guess I should be asking you, like, how did you feel when you heard that? Because right now you didn't stop. I'm like, that to me seems like the moment of all moments of today where you would stop and say, what? Like, you got...
I'm going to be honest. The first time around when I heard it, my anxiety was through the roof. So
okay.
I didn't even catch it.
Okay.
I didn't even catch that they had dropped the M charge. I mean, you could say it, but
yeah.
I didn't even catch it at that moment because I'm like, oh my God, he about to snitch. That's all that was going through my head.
You waiting for him to snitch. I mean, but they dropped, but okay. Can we go back for a moment? So last night, I don't know, people have Miss Sylvia. She's a divisive character, or divisive person, I should say. But last night, Charmel Drinks' aunt, a lady who says she's his aunt. Did you hear her on Miss Sylvia last night?
I did not see the stream, but I heard that there was a stream with an aunt, but I didn't see it.
All right, I don't know if you have any background with Miss Sylvia, because
I don't know her. I just know that her and Dennis go back and forth, but I don't know. Only time that I watched her coverage was this last week where I'm trying to find out what's going on with the mistrial, because there was no other source that was saying anything, and then all the people in the chat was like, Sylvia said this, Sylvia said that. So then I'm like, well, let me go to her page and see what she says, and let me go to, so I seen that her and Dennis kind of have a feud, but I don't know her. I didn't watch her coverage before this week.
Well, again, just making sure there's no kind of background that I need to know with you and Sylvia, but since there isn't,
I don't have no.
okay. So Sylvia had a woman on last night named, I believe, Miss Cain, Cain, who said she's Charmel Drinks's aunt, his mother's sister, his aunt. Now, he's a person who's no longer with us, and the DA says that Nichols, who we're looking at, and Shannon Stillwell, who's on trial as well, are the reason that Mr. Drinks is no longer with us, right? So Mr. Drinks's aunt is on, and she said it really is worth the listen, in my opinion. She's very frustrated with the DA. She said that they asked the family to come to the court yesterday by 3 p.m. and she said she herself didn't even know if she'd be able to contain her
emotions
toward the DA. She said they might have to lock me up for the way I'm gonna treat Hilton and Love, basically.
Why would they ask? Okay, sorry to interrupt. Why would they ask the family to come up there if they're giving out plea deals?
Well, I believe because Nichols was going to take a deal for unaliving, for doing away with, whatever term we're going to use. Try to use a respectful term, but for unaliving, for lack of a better term, her nephew. So I guess they were saying to, her sister, which would have been Mr. Drinks's mom, to Mr. Drinks's sister, so her niece, and I guess herself, just whatever family members would have wanted to come is how I took it.
So they can see justice with this plea deal?
Basically, okay. So they can be present. And of course they couldn't make it at that time. And interestingly, he didn't even sign the plea deal the plea deal until today. So I'm not sure what that's about, but she was correct though. I mean, she said he had a deal, and we see today he had a deal. So that was one of the reasons why today I was basing this whole, okay, Nichols has a deal, because I had heard what she said last night.
Okay,
so
I didn't see that stream last night, so I missed that.
Yeah, I heard it this morning, but it was from last night.
Okay, so I missed that completely.
So we get to see that they care. I'm not going to say they care more about, because it could be strategy, but the RICO charge, due to one reason or another, took precedence over the unaliving charge. And it might be strategy, it might be some kind of legal explanation that I don't know, but it doesn't look right, does it? It doesn't look good, where it's like, well, sorry about Mr. Drinks, but we're not going to prosecute that one. You know what I mean? Like, we're going to prosecute you having been a part of this enterprise. What did you do? As part of the enterprise, they're not even worried about that. Just being a part of the enterprise with a couple of acts in furtherance of the conspiracy, that's what they're really concerned with. So when I heard they were not dropping, but they weren't pursuing that charge, I was like, dang, like, how is this justice? You know what I mean?
Well,
especially
I think that from looking at it or listening to what they're saying, they're saying that he was in a separate car. He wasn't in the same car. Was he in the same car, or was it a different car? Because I'm hearing he was in a different car from the car that shot the shots.
I'm not. I'll be honest with you. I'm not sure. At this point, I don't even know what their case is against him, but because it seems like the facts on that are a little slippery, so I don't know exactly what. We'll hear it though. They're gonna mention that.
Yeah, they'll mention it. Again, my anxiety was through the roof, so I didn't even hear every single detail. But well, my opinion, what I would say is, yes, it's kind of a slap in the face to the family. Like, you're willing to let them go, but they've been showing that they've been doing this kind of thing all along. Like, they said that a week before Moontung took his plea deal, he's a danger to society. Don't give him bond. But then as soon as he does a plea deal, they release him and say, hey, you can go off into society. Now, my opinion, I think that maybe they feel stronger evidence against other people, and therefore they allowed him to kind of escape or slide off of the case. Now, a lot of people think, and this is what I was going to get to later on, but I'm going to just do a separate video and chop this up anyway. But a lot of people think that this does not hinder or work against the other defendants in any type of way. Now, I was wrong in thinking that this would mean that he would have to testify. However, I don't think that this is just a wash for all of the defendants. I don't think that they won't find a way to enter in his agreement into either the closing arguments or through a detective to show when they get to putting on the case for this part of the trial, because I think this part is supposed to come up next. I believe that they're going to put up one of those detectives and, you know, be able to say this person pled or whatever.
I'm going to say this, then I'm going to drop off. I'm going to watch, though. I don't want to take over your stream. I'm sorry. I'm just a bit of a, you know, I have a lot of this in my head, so I don't want to say too much. But I'm going to say something about that. I think they can make him testify, but they can't make him. They don't have the probation revocation to hang over his head. So they could make him testify in the same way that they made Woody testify, in the same way they made Quindarius Zachary testify, where you have to come in, you have to talk, but you don't have to say what we want you to say. See, with Tung, he had to not only testify, but he had to testify in a certain way, or he would go to prison. So I do think, for some people are like, well, he doesn't have to testify. I just think it's better to be more precise. If they want him to testify, they can call him, but he could then maybe plead the fifth and do all of, kind of be evasive, because this deal did not have probation revocation the way Tung did, like a probation revocation.
Right.
So they could bring him in, they could make him talk, but he could be evasive. He could say, I don't remember. He could probably plead the fifth and that sort of thing, where he doesn't really give them anything. Where Tung really had to testify for them. Nichols' deal doesn't make him have to testify for them, but they could probably still cause him to come in and testify in the same way that they did Woody.
Right. And that's something I said on my live earlier, too, just to put it out there.
Yeah.
I was
Okay.
because that's what I said earlier, though. I was like, listen, I said, if they can go to civilians who had one bullet hole in their car, who did not have a plea deal or any attachment, and harassed their jobs, harassed them, forced him to testify, ultimately, they can also subpoena him as well. It's just not a condition in there,
Exactly.
but they can still subpoena him. So that's what I said earlier. And you thinking along the same.
Listen, I'm gonna drop off. It's great to meet you.
No, I don't want you to go.
I was following
leaving?
you from back. I was like, I hope one day I can have a channel like she has. And here we are talking in real life. So it's excellent.
Oh, you're killing it. How long have you been doing YouTube?
You go back on our YouTube channel, it goes back to 2019, but we didn't get there was no traction with topical type of videos, but this trial and more current events has been like you do like more current events.
Uh-huh.
You know what I mean? And current events has a lot more traction. So I'm really interested in current events that have a legal angle, whether it's usually some kind of paperwork associated with it or court case or something like that. So I think I'm going to.
Why are you leaving so fast? They don't want you to leave.
They don't want me to leave?
No, they said don't leave.
Well, because I was on live this morning from 8:30 to 4 or whatever,
okay.
3 o'clock. So, I'm just trying to have a little bit of a life.
We understand.
But you know what? If, I don't know if you're on Twitter. If you want to plan something, I'll be happy to, if I could just put it on the schedule.
Okay, yeah, I'm spontaneous, but yeah, we can always run it back and do another live
you just
together.
pop on whenever. On whenever. Yeah. All right. Well, this isn't the first time that I've seen you since talking about this trial. It's just, again, I never really know somebody's vibe if they want to. I have seen you bring people up too. So you know what? If I see you on, I'll let you know.
Yeah, see, I'm not one of those type of streamers. Like some people, you see backbiting in coverage and people looking at each other as they look at each other as competition and I'm competing against it. hey, you killing it.
Thank
Keep
you.
on.
No, this is
killing
my
it.
first time coming up on somebody else's platform.
Yeah,
like
no,
this.
I talk to whoever. I don't care. I feel like you killing it. You killing it. I give anybody they props.
Well, you should come on our live then at some point too. We on here. Do you ever do live during the day, like during the trial?
Mm-hmm.
All right. Well, one day
I'm
when
always
you're not,
random though. Like I'm always random. So
well, randomly holler at me when I'm on live, so you can come up.
okay.
We can trade. Thanks everybody for watching. I'm gonna keep watching, but I'm gonna just be in the background.
Okay, for sure. All right.
Thank you. Nice
Thanks
meeting
for
you.
coming up.
Bye.
All right. So, what he said is what I said earlier, guys. I said that to people in the chat, and they're like, "No, that don't mean that he gonna testify. He is not testifying because." And I'm like, if they could pull Joe Schmo off of the street and make him testify, just because they didn't stipulate it in that agreement, they can still subpoena him and call him. But like he said, he doesn't have to play ball and give them the actual particulars and say YSL is a gang and, you know, the certain whatever is not stipulated in there. He doesn't have to say that. But let's look at the paperwork on his plea agreement. So this right here, hold on one second. These are all of his counts right here. So this is his paperwork. So right here, this is the state of Georgia versus Nichols. Hold on, let me make this document smaller, myself smaller, something. All right, so right here it says the Superior Court of Fulton County versus Nichols, and then it says these are his counts. He had count 1 in the indictment, count 49 in the indictment, count 50, count 51, 53, 54. So the first count was conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. They found him guilty of that. All of the other counts, they null pros them. So count 49, murder, null pros. 50, unlawful for person, employment associated with criminal street gang to conduct, participate criminal activity. Unlawful to commit offense with intent to obtain, earn, maintain membership, increase status, or position in, the street gang. No pros. Possession of a firearm by convicted felon, previously convicted of felony involving the use of, firearm. Possession of firearm or knife during the commission or attempt to commit certain felonies. No pros. So, hold on. My phone is ringing back to back, child. Hold on. Child. Okay, so then count 65 right here where it says use of a firearm by convicted felon. No pros. It says his general conditions. Let me pull up. Hold on. We'll read through that after this. Hold on. Let's finish watching this.
Well, there's only one charge that
so
a guilty plea is being entered into, so
under my breath to that.
there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
What they talk about immigration status, is he not a citizen? Where he from?
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And that can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to
Hang on just a second. You also have, so 4 years for that to file a direct appeal. You have 30 days from the date of sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that, but that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right. Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence, that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steel Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle when that vehicle was searched, Your Honor. This was in October of 2018. They found marijuana as well as sandwich baggies that would be used to package drugs, and there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Wooney Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas, but carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at the early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMiller and Darius Ford. It also then included a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got into his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in.
All right, so I'm going to pause it right here because when she was reading all this, I was waiting for the part where she was going to say that he was snitching. So I missed it. So basically what she said so far was what they have on him as it pertains to that particular murder was he drove in his red Ford Fusion. Shannon Stillwell was in his Audi. The victim drove into the gas station in his car. There was a call made between the two. And then I'm sure she'll say next that then, you know, it happened.
That communication was to the effect of you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving as well as the car that Mr. Nichols is driving both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle.
Okay, so what they have is basically speculation that they must have did it. So it sounds like they don't have actual video that shows them shooting Shamel Drinks. What they have is both of them are at the gas station. Shamel Drinks goes to the gas station. They leave the gas station. They're both following him as they leave the gas station. They approach the light, and once they approach the light, one car is in the far right lane, one car is in the middle lane, and then Shamel Drinks' car is, I guess, at the light as well. They both drive off. Shamel Drinks' car never moves, and a Good Samaritan comes 30 minutes later to realize that he was deceased. So there's no video that shows them shooting, but the shooter could have been him or Stillwell, according to what she just said. Let me bring that back real quick and make sure that I'm understanding correctly, because earlier, like I said, my adrenaline was high, so I wasn't listening attentively. I was just waiting for them to say he is snitching, he gonna snitch, and he gonna testify, to be honest. So let me listen a little bit closer to those details.
Shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred.
Wait, I want to go a little bit more past that part.
His vehicle, which is the Audi. At some point in time, Mr. Nichols got into his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect of, you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving as well as the car that Mr. Nichols is driving both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane.
Okay, so basically, Shamel Drinks is to the left. Shannon Stillwell car is, okay, so I got my makeup brush, some scissors, and my lipstick. Or this card. Okay, so this is the victim. Or let's say this is the victim, since this is the left to y'all. This is the victim car. The scissors is Shannon Stillwell's car. And then my makeup brush is the one that just took the plea car. So this is the setup. Victim's car, Shannon Stillwell's car, this car, and they're all three at the light.
This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We had know through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and then kind of follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out, on March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, I won't call it a high-speed chase, but there is a chase through.
Okay, and this is the surveillance that we've seen where they leave the Chick-fil-A and then they run up into some neighbor's house. They run to get away. I'll pull up that surveillance. I think End of Sentence had posted it. We'll watch that.
The city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended after arrest warrants were ultimately taken out for the murder of Mr. Drink. Given where we are in the case, Your Honor, we know that we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made a decision to move forward with this recommendation for the RICO count, Your Honor, for count one.
Mr. Harvey, are y'all acknowledging a factual basis to the count one, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So.
All right. So now listening to Harvey again, I stand on what I said earlier and what paralegal just also stated as well. In my opinion, they're definitely calling him to the stand. What Harvey did right here was give him the alley-oop when he gets on the stand. And all of the other attorneys, when it came to Munktunk, he didn't get up there when they were accepting the plea and say, I disagree to this part, I disagree to this part, I disagree to this part. So therefore, if he does get subpoenaed, which I believe he will, I don't believe that the state is going to give this sweet of a deal without some type of take from them. They give him a plea, and he still, even though that's not stipulated, they still can call him. And this was the alley-oop, to me, in my opinion, to help his client when he gets on the stand. when he gets on the stand and they say, hey, you participated in this murder, they can't say that he participated or that he agreed that he participated in the murder, because Harvey is saying he did not participate in the murder. However, that does not mean that they won't call him, and that does not mean that they won't ask him other questions. They still can subpoena him. He was a part of YSL. He was there that day. Now, more than likely, given that Harvey did amazing lawyering and he does not have to admit that he committed the M offense, then when he gets on the stand, that gives him the alley-oop to be like, you know, I don't recall, you know what I mean? It gives him that opportunity, but that does not alleviate him from not being called altogether. That's my opinion. This is not saying that he absolutely will not be testifying at all. This is just saying, listen, we can't make you say these particular things on the stand. But if y'all think for 1 minute, they have called people to the stand that had one bullet hole in their car. They have called people to the stand that had like 1 or 2 bullet holes in their house. And y'all think that because he took this plea deal, they're going to be like, okay, well, thank you, Nichols. We don't need you at all. But we needed to harass the guy who had 1 bullet hole in his car, and we needed to harass him. I don't believe so. I believe that he still is going to be called. However, Harvey is an amazing lawyer. He's similar to Ashley Merchant. When their plea deals with their clients are compared to other plea deals with others' clients, it's a stark contrast in that. But I stand on that. All the people who are saying that this can't be used against the other defendants, they can call him up to the stand and say, did you plead guilty to RICO? Did you plead guilty to conspiracy? And the things that he admitted within the RICO, yes, on the surface level, us who are watching is going to be like, oh, well, he committed a drug offense. He pled to having a firearm. That doesn't really help them. And that's how a lot of people have looked at a lot of the other people who have come on the stand like, oh, Moontunk, he was shooting for a girl in a love triangle. That doesn't really go against the defendants. It'll be the same regard with him. So not that it won't affect them at all. You don't know what the jury is thinking. There's a lot of times where a lot of people think because they think something, that's what the jury is thinking. The jury can be looking at this a whole total different way. You can't assume that these things that you think are insignificant or you think are not a big deal, or you think it doesn't link them as a criminal street gang, that doesn't mean that the jury will look at it in that same way. They could look at him having a firearm and him being at the scene and him being at the light and whoop, all of those things as proof that he helped do it, whether he got off or not. Just like Woody had immunity. You think that the people who are looking on the jury think that because he had immunity that he's squeaky clean? No, he still had things that he did that he admitted to that does not reflect good on YSL. A lot of people who I look at on the chat, they're like, oh, Lil Woody did his big one. You know, Lil Woody, he was a part of YSL clearly. He was shooting up people's houses. He participated in the nefarious behavior of all of them. So you can't assume because you think his actions in that wasn't a big deal that the jury won't look at that and be like, all of these people are delinquents and they deserve to be off the street. Okay? So let's continue some more.
But yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, we just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL.
Okay.
And that concludes our factual basis.
And again, once again, we again categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case, and to which Mr. Nichols has previously pled.
All right, thank you, understood.
And Your Honor, may I approach with the waiver of rights form?
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in each individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea, and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
Very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days, and he will be 30. And at 30 years of age, he has a wife, he has got a 13-year-old daughter, he's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta, and you know, we're at this point before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning, and he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I asked the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count 1 of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy, and that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count 1 of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count 1 is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. No. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe Mr. Harvey is correct, can be a productive member of society, and this is an opportunity for you to do that and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
All right, so I want to talk to y'all a little bit about some of the misconceptions that I see, and some of the misconceptions that I had when I first started covering trials, and I didn't have a lot of knowledge. And, you know, when I went to the Tory Lanez trial, I didn't have the proper understanding of reasonable doubt without I didn't have a proper knowledge of what reasonable doubt meant, right? So in my mind, I thought that, you know, if somebody proposes a theory opposite to what the prosecution is posing, then did they prove reasonable doubt? And as I started to get more knowledgeable about cases, as I seen the verdict in the Tory Lanez trial, and as I started to cover more trials, I started to pay more attention to the way language is. I started to pay more attention to verdicts in cases. I started to just, like, after I watched that trial, it really made, like, it set a fire into me to want to learn more, to want to find out more, you know? So when I first covered the Tory Lanez trial, there was all of this talk about, oh, you know, it could have been Kelsey. It could have been not Tory. And in my mind, because I didn't have a proper knowledge of what reasonable doubt truly meant, I thought that, well, they didn't prove that it wasn't Kelsey all the way. Like, they didn't prove it, so maybe they didn't prove reasonable doubt. And that's not what it is. Basically what it is if it's not plausible, if the theory that the prosecution is putting on is closer to the facts, spot on to the facts, and the theory that the defense is putting on, given looking at the evidence, does not make sense, then it's not reasonable doubt that that is what happened, right? So I'm not sure if that came off or if that was clear, because I feel like it kind of came out jumbled. So let me repeat. Let's say we have, for an example, the Tory Lanez case, right? Where Tory Lanez had the jail call. He had the post on the Shade Room where he said that Kelsey was not the shooter. He had the text messages to Megan where it showed that he was apologetic. It showed him and Kelsey on the call, and he's the one apologizing, but he's supposedly apologizing to the shooter. They also had the audio of the gunshots. They had body cam footage of the aftermath. They had Kelsey's demeanor. They had Meg's demeanor. They had Tory, all of them on body cam. They also had Kelsey post or her text messages 5 minutes within the shooting saying, "Help, Tory shot Meg." So when you look at all of the evidence and you see that he had GSR and Kelsey had GSR, but you look at all of the other elements and you see that there are experts that testify that if somebody shoots close proximity, GSR could get onto another person, and then you collectively stack that with the testimony that the eyewitness says that he's seen the shorter guy doing all of these shots, And so a lot of people like to point out the fact that, oh, well, he said he's seen a girl shooting, and then he said that he's seen Tory shooting. A lot of times people are going off of the black and white that they see, and they're not going off of, like, when you're in court, when a person is testifying, the way they're testifying, the voice, their demeanor, their, you know, if they're coming off trustworthy or not. When he got to the point where he said it was the shorter guy that was shooting, he was very for sure in that. Like, it sounded like he was confused at first, but he was very for sure when he said that part of it. And then when you cross-reference that to the actual audio of the gunshots were boom, boom, a very slight pause, boom, 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 and it was very consecutive. It's not consecutive with it being two shooters. It's not consecutive with it being Kelsey bust off a shot, then this guy bust off a shot, or they're struggling. The facts does not point to that. If you follow the facts, they point to Tory as being guilty. And it's not reasonable giving the facts that it could have been Kelsey if you're actually looking at the facts of the case, right? So when I was first looking at it, I was thinking, you know, oh, well, if they made or they threw out this theory, then did they really prove it? No, it's based on the facts, and if it is plausible for the theory that they put out to happen, given the facts. And it's not plausible that Kelsey shot Meg, no matter how much people are in denial about it, given the facts. So in this case, what I've been seeing a lot of times too is, especially when it comes to Woody, right? A lot of people think that just because somebody says something, that means that the jury has to believe that something, right? So not too long ago in my chat, let's see who wrote it. Let me see if I could go back to it, and I'm gonna read it verbatim because I wanted to reply, because they said Little Woody said, hold on, wait, let me find it. Hold on 1 second. Oh, dang, no, hold on. It's going too fast. Wait. Okay, I can't. Hold on. Anyways, they said something along the lines of Little Woody said, oh, God, I want to read it exactly. Hold on. Damn. Because y'all know I got to be right. Hold on. Wait. The court did not acknowledge Tory's innocence. And y'all got to stop going off of misinformation. Somebody said Tory was done dirty. That's why he's about to get out. The court acknowledged his innocence. No, they did not. They said they would hear his motion or whatever it's called, but they did not say, hey, Tory, this means because we're going to hear it, that means that you're innocent. That's not what they said. Hold on, wait, let me find it. And then I'm going to go back to the person who claims that that means that Tory is innocent, because they're not. That's wrong. Okay, I can't find it, child. I'll be here forever. Oh, here we go. Somebody said, Woody clearly said that he did his dirt on his own, had nothing to do with YSL, right? So this is what I want y'all to understand. Just because somebody makes a claim does not mean that a jury believes that he did the things on his own. So I see a lot of this type of rhetoric when I'm watching the trial, and a lot of people think that, oh, well, as long as Woody said the contrary, then, you know, how can the jury believe otherwise? They have their own common sense, they have their own brain, and they have their own mind. So just because you tell me that you did it on your own, and and I'm looking at the evidence, and the evidence shows, and it doesn't show that in the case, but I'm just saying hypothetical. Because I don't think that they proved that they were doing this in furtherance, but I'm just saying this as hypothetical. If I believe that you did it in furtherance, and I'm looking at the evidence, just because you said that you didn't do it in furtherance does not mean that I believe that you didn't do it in furtherance. You get what I'm saying? So a lot of people have this this idea that when these witnesses get on the stand and they play dumb, a lot of people think that that means that the jury is dumb. That doesn't mean that the jury is dumb. That just means that just like you and I are looking at the testimony and we see that he's BSing, the jury are just like you and I. We see that he's BSing. But a lot of people will take that and they'll be like, oh, well, he said that he didn't do it. So that means that, of course, he didn't do it then. It's like, that's not what that means. Just because somebody says, oh, I didn't cross the street, that doesn't mean that they didn't actually cross the street. You got video of them crossing the damn street. You get what I'm saying? So I just wanted to make that point. My word don't mean a damn. But I just wanted to make that point because I kept seeing people say that, and I'm like, no, that doesn't mean that. But for the Tory people who think that mean that he innocent, let's hear from this attorney that was in court and made y'all believe that. Let's hear from a lot of the Tory fans go to for coverage. Let's see what he says about it.
Tory Lane's innocent claim accepted by appellate court, giving DA 2 weeks to respond. Let's talk about what this means. So first off, when they say accepted by the appellate court is just saying they're going to hear the appeal. They're not saying, oh, we're letting him out or we believe he's free. They're just going to listen to what his appeal is. That's all that means. Now, what is his appeal?
Did you hear that? For the person that say he innocent, blah, blah, blah. Let me bring it back.
First off, when they say accepted by the appellate court is just saying they're going to hear the appeal. They're not saying, oh, we're letting him out or we believe he's free. They're just going to listen to what his appeal is. That's all.
Did you hear that? Let's bring that back one more time.
Tory Lane's innocent claim accepted by appellate court, giving DA 2 weeks to respond. Let's talk about what this means. So first off, when they say accepted by the appellate court is just saying they're going to hear the appeal. They're not saying, oh, we're letting him out or we believe he's free. They're just going to listen to what his appeal is. That's all that means. Now.
So what that means is I'm going to hear what you got to say. But that don't mean that I believe you. That don't mean that you're innocent. That don't mean that you're going to get let free. So you have all of these Tory stands, and I love Tory Lane's music. I love his music, but I'm not a stan of nobody, and I'm not, I got some comprehension skills. A lot of people are spreading misinformation based on that, oh, Nick, I see you ain't talking about it. What is there to talk about? There has not been a change in his case. They said that they're going to listen to it. They didn't say that they was changing his outcome, resentencing him, saying that he innocent. Nothing like that has been stated yet. But you have all of these Tory fans running around saying he's innocent. And you know why he's doing all it? I'll do a separate Tory video. But
what is his appeal? It's pretty good. It's been made in a couple different ways, and you have to understand the different court processes that are involved. One, they asked for a new trial on the basis that there's this evidence, the affidavit from the driver. The driver could take the stand and testify. He was working security that night. He was the only one not drinking at the party. He saw two women fighting. He saw Kelsey with the gun. He saw if he took the stand, according to his affidavit. Now, the court in the appeals case said, yeah, but we can't give you a new trial because Quan was in court and your lawyer said we're not going to have Quan testify. So that's on you. But this is different. This is a writ of habeas corpus. In Latin, it means bring me the body. It's a Hail Mary. It's a writ of last resort. It's what the courts have set up so that if you've tried to appeal on every other basis, you can always tell the court to bring me the body and just see what the hell's going on here. And you have to have a very good argument for what the hell's going on here. Their very good argument, this is actual innocence. Whether or not I tried or I could have or I should have, I'm innocent. Let me.
Okay. So basically, it got
Tory
cut off,
Lane's
but what he's
innocent.
saying is, what Tory is saying is, I'm innocent. I didn't do nothing. Listen to my case. I'm innocent and everything like that. That doesn't mean that he's going to be found innocent or that he's been proven innocent. That means that Tory believes that he himself is innocent. That does not mean that the court believes that Tory is innocent. That does not mean the court has deemed Tory to be innocent. That is not what this says. That is not what it means. So I just wanted to comment to the person who said that, because you have a lot of misinformation going around, and that's one of them. I'm one of the type of people that I don't know everything. Okay, I give my opinion on a lot of things, and all of that. But if I'm wrong, I'm wrong. If I'm right, I'm right. A lot of people are giving misinformation as it pertains to Tory Lanez, like extreme misinformation. And it's the same people that y'all listened to during the course of the trial, giving information that was inaccurate before. So, you know, it is what it is. But I say that to say, bring it back to my other point, was just because a person says, oh, I didn't do this or I did that, it doesn't mean that the jury actually believes you. That was my greater point. Just because you get on the stand and be like, oh, I didn't slap the girl, but she got 5-finger imprint in her face, and the last motion we seen your hand go like this. When you get on the stand and say, I didn't slap her, that don't mean that we're going to believe you. That just means that that's your assertion of it. But yeah, that's all for this video. I'm probably going to clip up this video and, like, you know, make it more concise or whatever, to the point. But what topics do y'all want me to cover? I see Street TV up in the cut. He don't want to come up. I asked him to come up. He don't want to come up. But Street TV in the cut. Is there anything that y'all wanted to say? Oh, thank you. You said you've been shot before in your arm. It's no way that I guess you meant twerking on live the next day. She wasn't shot. A bullet didn't shoot her through her foot. That's the misconception that y'all keep saying. She was shot, as far as like the bullet ricocheted and hit her foot, and there was a hole in her foot from the bullet. But there was not, like, the bullet wound that you got in your arm is not the same bullet wound that she got in her foot. Like, she did get injured from the bullet. Okay, it's not the same injury that you got. She got injured though, is what I'm saying. But all right, Street TV don't want to come up. We'll chat next time. I'll catch y'all on the next one. Peace. Oh, and do y'all want me to do a separate Tory stream? What y'all want me to talk about next?